going to say a few words of introduction to introduce you to the topic, and then I'm going to introduce the three speakers we have, and we're going to have a Q&A session, and I hope there's going to be some time to bring you guys in with your own questions too. So the topic of the discussion is the role of effective legal aid services in the context of the global growth of systems that involve waiving the right to a fair trial. So they can be called plea bargaining systems or cooperating witness systems or many different names for this practice. But effectively, we're talking about that. It struck me earlier on when Jennifer was talking about the fact that there are lots of dynamic changes at the moment to legal aid services, and one of them was restriction to the point at which, restrictions being imposed in terms of the point at which legal aid is being provided, and sometimes that being restricted to the trial itself. And I hope this discussion kind of demonstrates how important it is that we resist those restrictions really vigorously, because many people end up with criminal convictions that never go to trial at all. So the starting position, as with so much in this discussion, is that everybody is entitled to a fair trial. It's the starting position. The reality, though, is that many, many people end up with criminal convictions not after having had a fair trial, but having waived their right to a fair trial and accepting guilt. The US is the famous example of this, and Rick Jones can tell us a bit more about that in a moment. But in the US, 97% of federal convictions result from plea deals. Fair Trials was increasingly concerned about the number of human rights activists and lawyers that were coming to us and asking about these new systems that were being introduced in their countries to introduce plea deals. And we were getting so many of these requests that we decided we should do a survey. We should do a global survey of which countries now have these trial waiver systems in place in their laws. There were some reports outside. I think most, if not all, have gone. But grab me if you want a copy, and I can email it to you or post something to you. So we started looking. We looked at 90 countries. We started looking at in 1990, and you can see here 19 of the 90 countries we looked at then had some form of trial waiver system. Over the following 10 years, another 13 countries introduced a trial waiver system. The following 10 years, from 2000 to 2009, a further 22 countries introduced trial waiver systems. And in the final slot, from 2010 to 2016 that we looked at, another 12 introduced trial waiver systems. So the first conclusion of this study that we did was that trial waiver systems are growing globally. Now, another interesting finding of the study is that there's a massive difference in terms of how much a country with a trial waiver system or a plea bargaining system actually uses it. But many countries rely on trial waiver systems, plea bargains, very extensively, including the US, but also including Georgia. So we looked at the rate of convictions which resulted from plea bargains here in Georgia. We only have data up to 2012, and I think one of our speakers may be able to provide some more information on that. But it had risen in the 7 years since its introduction to accounting for over 80% of convictions resulted from plea bargains. So once this system is in place, it can quickly become a really dominant feature of criminal justice systems. So why is it being introduced? Loads of great reasons for introducing plea bargaining systems. And Fair Trials is certainly not opposed to them in principle. Efficiency, a key reason. Modernizing the criminal justice system. I don't really necessarily know what that means, but that was often the reason that was given. Tackling impunity, fighting complex crime. So how do you get somebody to cooperate and give evidence against another accused person in a complex crime? Victims' interests, and improving human rights protections, interestingly. So here's again the picture I showed earlier of pretrial detention rates. So lots of human rights activists have been pushing for more efficient criminal justice systems as a way of reducing pretrial detention. And one of the solutions that's been proposed, and I think we'll hear a bit about that in the context of India, has been plea bargaining. So, problems. There are problems with plea bargaining systems if they don't have appropriate safeguards. So, innocence. So this is, the systems can be structured in such a way that it makes sense for an innocent person to plead guilty to something they didn't do. Seems to me like a terrible idea for a justice system, but there you go, that happens. Torture and oppression. How do you prevent people being tortured or coerced into pleading guilty? Unreliable evidence. If you're offered a deal as a cooperating witness, can you really trust the evidence that the cooperating witness has given? Open justice, for me, this is a big one. I think that the actual trial, when people are present in court, is really crucial to demonstrating how police and prosecutors operate. If a system is overtaken by plea bargaining, you get none of the transparency benefits of an open legal process. A huge concern. Corruption, equality before the law, I think in some jurisdictions, I think this was the case in South Africa for some time, it was really just kind of rich people that could benefit from plea bargaining systems and get the sentence or charge reductions, not other people. Overcriminalization, sentence inflation. So Fair Trials is calling for a rights-based approach to plea bargaining. At the moment, international guidance on human rights offers almost nothing in terms of telling us how to structure a fair system for plea bargaining. We at Fair Trials think that really needs to change. There was a resolution just a few weeks ago from the Parliamentary Assembly of the Council of Europe, which says that we do need safeguards, appropriate safeguards, to ensure the fairness of these plea bargaining systems. So the process of defining what fairness looks like in those systems has started. And our aims to show that this reliance on trial waiver systems is a growing phenomenon, to develop the international human rights framework that addresses the reality of criminal justice now. So when you think of the ICCPR and the European Convention, they were all developed at a time where plea bargaining wasn't such a common thing, and therefore they're completely silent as to the human rights protections in that context. That needs to change. And to help local experts in countries across the globe to advocate for fairer trial waiver systems. So it's a Q&A. I'm going to shut up. And I'm going to introduce three brilliant speakers. Rick Jones, who spoke earlier on from the Harlem Defender Service. Rick, thanks for staying awake for this session. I know you've flown in from the west coast of the USA. That's a long way. I'm sure Kakha and Madhurima will nudge you if you fall asleep at any point. Kakha Tsikarishvili from the EU-UN joint program here in Georgia. And Madhurima Dhanuka from the Commonwealth Human Rights Initiative in India. So I'm going to sit down now, and I'm going to ask you a few questions. Okay, so my first question is for Rick. So the US is very much seen as the home of plea bargaining. Can you just say a few words about the role that plea bargaining plays in criminal justice systems in the US?
Sure, and I will say very few words because I hope that we have an opportunity to get to questions. The figure was quoted that 97%, I think, of all federal cases in the United States resolve themselves through some sort of plea bargain or negotiated plea, and the figure in the state courts is equally as high, 95 some odd percent. I will tell you that plea bargaining is one of those things in the United States. There are many things that are wrong with our justice system. Our justice system is broken in many ways, yet nonetheless people all around the world want to model it. I don't know why, but they continually want to do that. Plea bargaining is a corruption, a perversion. It's corrosive in our justice system. We should do everything that we can, if not to eliminate it and abolish it, certainly to contain it and make it a much less substantial part of the system. It negatively impacts every aspect of our justice system, from massive pretrial detention to over prosecution, to over incarceration, to mass incarceration, to the collateral damage of collateral consequences. Just about every problem that you can find, the dropping at the doorstep of the criminal justice system, all of the societal problems that we have, from mental health issues and other what are really medical issues, to veterans issues, to homelessness, are all dropped at the doorstep of the criminal justice system because of plea bargaining. We have the ability to widen the net and to handle much more cases. A judge who operates a court from 9 to 5, who should really be handling 4 or 5 matters in the course of a day that really require the right of a fair trial and the right to be heard by a jury of your peers, is now handling 40 or 50 cases because of plea bargaining, and everything under the sun is coming up before the criminal justice system. We've now expanded the cottage industry with the rise of the mass of the prison population, the sort of prison industrial complex, the numbers of probation and parole officers that we've got, the number of folks who are monitoring people who are living with convictions. All of these things can be traced to the doorstep of plea bargaining, and I really think that I don't want to. I mean, I could take plea bargaining to the fall of civilization because it really is that bad of an idea. It really is form over function, and all of the checklist of items that were on the screen, none of them seem to me to hold any value really when you think about the individual and the right to a fair trial and the right to have your contest heard by a jury of your peers. So plea bargaining really has been a bad idea. I'm sorry to see that it's spread so widely and is continuing to spread throughout the country. But I really stop there and let you ask the next question. Maybe we can get to some questions from the audience. Bad idea.
Yeah, I think we gathered that, Rick. Thanks. Thank you. Kakha, I think plea bargaining is not as established in Georgia as in the United States, but it's been around since the early 2000s. Can you just say a few words about why it was introduced and what role it now plays in the criminal justice system here in Georgia?
Mm-hmm. Oh, okay. This is no, maybe this one. Okay. Thank you very much for inviting me to this panel. First of all, I must give you my background. I'm not a criminal procedure guy. I'm I teach substantive criminal law. And from substantive criminal law, I can say a lot of criticism about plea bargaining because somehow it plea bargaining somehow has some contradictions with substantive criminal law, but this can't be the focus of today's debate. Just to answer your questions, I would say that Georgia has introduced plea bargaining in 2004, starting from 2004. Before this time, Georgia had a completely, mostly inquisitorial criminal procedure with mandatory prosecution, with inquisitorial powers of the judge. And from 2004, we started to introduce some adversarial elements, including the plea bargaining. Now, just a few words about statistics. Statistics were 12% of cases in 2005, then increasing 30, 40, 50, 70, and in 2013 we had the highest number of cases, 90% of plea bargaining in 2013. But then it started to decrease again, and now it's more or less 60-70% of cases are plea bargaining cases and plea bargained cases in the trial courts. Just a few words about the Georgian plea bargaining system. First of all, for what kind of crimes the plea bargaining is possible? I'd say there's no limitation. It can be applied for any crime. The legislation does not have any limitation for that. Now, the second question do we have a charge bargaining or sentence bargaining? I would say that mostly we have, it's possible by the law, it's possible to have a charge bargaining and a sentence bargaining, but in practice, it's usually a sentence bargaining. The defense and the prosecution, they agree on a specific sentence, and the sentence is usually approved by the court. Then, what is the role of the court in the plea bargaining process? The role of the court is quite limited. The court is supposed to check whether the plea is voluntary, whether the defendant is informed, whether the procedures have been observed, and if there is adequate enough evidence for conviction of the person. But in most cases, I would say 99% of the cases, the court usually approves approves. Now, a fourth point I would say, which is also interesting, which could be interesting for you, is that according to the Georgian Criminal Code, the judge has no power to apply the minimum, the lower than minimum sentence. For example, if the minimum sentence is 5 years, the judge has no power to go below 5 years. We have a lot of minimum sentences in the criminal code, and the judges are restricted to, by these mandatory minimum sentences. But the prosecutors, they are not. The prosecutors, they can agree on a sentence which is below 5, on 3 years, 2 years, 1 year, and even probation. The prosecutors have a lot of discretion, and the judges have these minimal sentences that they cannot go, down. At this point, I think I'm going to stop, and then later I will have some more opportunity. Thank you.
Yeah, you will. Madhurima, again, I think even more recently, plea bargaining was introduced in India. And in my slide on pretrial detention rates, I suspect India did pretty badly. I'd be really interested to hear the rationale for the introduction of plea bargaining, but also your impression of whether it's living up to the promise of increasing efficiency and reducing pretrial detention.
Okay. So you're quite correct. We do suffer from a very high pretrial detention rate. But what we also do suffer from is very high criminal case pendency. So as of today, there are approximately 20 million criminal cases that are pending in courts. And of these, 88.6% are actually pending in magisterial courts, which means they are of lesser offenses. If you look at plea bargaining, so the data that we have that's collated, it says that only around about 0.028% of cases are actually disposed of using plea bargaining. So this, of course, brings us to a problem that A, we have high pretrial detention rates, B, we have a lot of pendency. At the same time, plea bargaining hasn't really hit it off. Very few courts, very few lawyers even advocate for its use. Most people are not even aware that it exists. And again, in India, there is a very limited scope where you can actually plea bargain. So again, we don't have bargaining at the time of charge. It's only at the time of sentence. So you have to be charge sheeted, only then you're eligible if you qualify. So they are also specified offenses under which you can apply for plea bargaining, and it's usually 7 years or less, and all socioeconomic offenses, all offenses against women. So there's a whole list of offenses which are excluded from the list where you can plea bargain. However, at the same time, you also talked about plead guilty. And in the Indian context, both are different because you can plead guilty for any offense. There's no restriction there. But to plea bargain, in terms of the procedures that were introduced around 10 odd years ago, for that, there is a limited scope of the offenses where you can, which I was talking about. Now, even there, the distinction also comes that if you plead guilty, then you would, if there's a minimum sentence, you can't go below that. But in a plea bargain, if there is a minimum sentence specified, and it's not there for most offenses, it's usually a maximum, but where there is a minimum in plea bargain, there's an incentive that you can either get 1/4 or half of the sentence, depending on what your offense is. So there is a distinction in this regard. In terms of plead guilty, I would say there are more cases where people are being forced to plead guilty, and those numbers might be higher, but we don't have that data is not there in cases where people have pled guilt. So maybe the numbers in terms, if you're looking at plea bargaining, which includes both, then we probably don't have the numbers. But then that's been there forever. You always had the option to plead guilty, and the trial has it will be a shorter trial and it will be over. So yeah. So to answer your query, I'm not sure I think it's going to take a long time to be able to use plea bargaining as a mode of increasing efficiency in the criminal justice system. There are a lot more things we need to tend to first before we come to it. Yeah.
Sorry, I'm going to come straight back to you, Madhurima. Just in terms of, you already alluded to one, but would you have concerns about how the increased use of guilty pleas or plea bargaining systems, whichever, in India might play out, given how the criminal justice system operates in India? Do you have any concerns about risks in terms of increasing reliance on that system as a way of getting convictions?
Well, I'll go with Rick here, and I'll be like, where do I start about the concerns? There are many concerns, and I'll tell you a small story about a case that that was brought to my notice many years ago. There was a mentally ill woman in one of the prisons, and we were informed that she had, after taking medication, she had become well. But and she was convicted of being a foreign national, but she actually belonged to India, and she had family. So we went to court seeking her discharge and her release from the prison, and the High Court actually ruled against it because they said that she pled guilty. So she was mentally ill in that condition. She was made to plead guilty, and now that came back to her, and she could not get out because of this. So this actually, this example tells you about all the things that are wrong. If prisoners do not know what are the consequences of pleading guilty, if a person is not informed, there's no counseling. The provisions don't, as you said, there are no safeguards. So there's no provision to even counsel the prisoner or any accused person on what are the consequences of pleading guilty. That's of course one of the primary concerns. And as Rick said, all the other issues that are part and parcel of the criminal justice system, similarly they come into play here. And I think legal representation here is more important, because you are pleading guilty, you will be convicted for a crime. And not many people are aware of what are the implications of being a convict. And so, yeah.
Thank you very much. My understanding is that one of the concerns or criticisms about the plea bargaining system in Georgia all related to this question about whether or not people really understood the implications of the plea, and certainly there's not many cases that have gone to the European Court of Human Rights on this question, but one of those cases is in relation to Georgia, and I think that was a kind of key finding of the court, the importance of understanding the implications of the plea. I wonder if you could say a few more words there, Kakha, about some of any other concerns that have been raised about the practice in Georgia.
Of course. I mean, this is a topic that probably you can talk for hours, but we try to be as brief as possible. There are a list of arguments against plea bargaining in Georgia as well as outside, of course, and also arguments in favor of the plea bargaining. And some of the things were specific to Georgia. I would say 10 years ago or 8 years ago, some of the issues were very sensitive for Georgia, and I would mention some of these issues, particularly a possible pressure on a defendant to plead guilty, and several pressures. I mean, pressure number one, very low acquittal rate. The acquittal rate in Georgia in 2007, the acquittal rate was 0.01%, if I'm not mistaken. 0.01% was the acquittal rate. The second, high detention rate. That is, if the prosecutor filed a motion for detention, there was a 90% of chance or 95% of chance that the motion was granted. So 95% of prosecutorial motions for detention were granted by the court. This is also this is a part of the pressure on a defendant. Pressure number three was, I think I told you about the mandatory minimum sentences. For example, I have committed a theft, and it's an aggravated theft, and the sentence is from 3 years in jail. And the prosecutor comes and tells me, and you have to plead guilty or you go to 3 years in jail. And I say, well, do I have a chance to be acquitted? But if the acquittal rate is 0.01%, so I don't practically have chance to be acquitted. Okay. Then I start thinking about, there's no possibility of acquittal. There is a high possibility of. The defendant is in detention, so he wants to get out of jail, and the judge does not have a possibility to apply a lower sentence than the minimal sentence. And in this case, the defendant doesn't have a big choice. Either, even if the defendant is innocent, he doesn't have a big choice. His choice, he has to plead guilty or go to jail for 3 years. So in this case, a reasonable defendant, a typical defendant, would probably plead guilty in spite of being innocent on a specific case. There is a likelihood that in such a system, the innocent people may plead guilty because there is too high pressure. There's a too high pressure on a defendant. In this case, there is the importance of the counsel becomes, of course, huge important. It becomes very important. The role of the counsel becomes very important, but it also has its limitations. What can the counsel do if there is such a low acquittal possibilities and in the country? That was part of it. But after some time, from 2013, the acquittal rates became higher. 2%, 3%, 4%. So they rose up. The prosecutorial pressure on also the prosecutor's motion for detention are granted with less percentage, like only 60% of prosecutorial motions are granted, but however, even today, the judge does not have a power to go below minimal sentence. And this still continues to be high pressure on a defendant because we have high mandatory minimum sentences. And I have a question particularly about the plea bargaining when it comes to a procedural economy. And this is a question which is also discussed here in Georgia. How far a procedural economy can become a ground for the reduction of the sentence. In other words, how far can you trade a procedural economy for a sentence? Let's suppose that I have committed a crime of robbery, and my sentence starts from 7 years to jail, and according to the goals of punishment, according to the substance criminal law, for the purpose of prevention of the crime, for retribution, for general prevention, 7 years is the right sentence, is a correct sentence. For all purposes of the punishment, 7 years would be the right sentence. Okay, but when the prosecutor comes to the defendant and starts trading, and says, we can agree on 5 years if you plead guilty. And defendant says, no, 5 years is too much. Then prosecutor says, okay, 4 years if you plead guilty. And the defendant says, okay, 4 years is fine. Then what happens, my question is, what happens to this 3 years, which was the just punishment for the defendant? According to I'm talking as a criminal law professor here, according to the criminal law. So this 3 years of sentence was exchanged for the procedural economy. And my question is whether this is legitimate to exchange punishment just in a pure case of procedural economy. I'm not talking about trading justice with justice. For me, this is fine. When you are trading justice with justice, it's fine. You are catching a big fish. You are clearing the crime. You are obtaining evidence on the case. And for me, this is fine. But trading punishment for procedural economy, that means trading punishment for money, because procedural economy is money. And this is a concern that I have. How legitimate is that? And this is one of the questions.
I'm not going to try and answer it because I want to get some questions from the floor, and it's a really difficult one. Rick, I'd like to ask you, I've heard from judges and prosecutors in the past that the US criminal justice systems would collapse if it weren't for plea bargaining, and I just wondered whether that was the same for legal aid services, whether public defenders' offices would also collapse if it weren't for plea bargaining.
The criminal justice system would not collapse if there weren't for plea bargaining. The public defenders' offices would not collapse if it weren't for plea bargaining. What would happen is if there were no plea bargaining, you would right-size the criminal justice system, and people would be able to do their work in the way that they're supposed to be able to do their work. Justice systems should not be about prioritizing, as Kakha was saying, should not be concerned with prioritizing efficiency over justice. They should not be concerned with prioritizing efficiency over fairness and equality. That's what we look to our justice system for. And so if you took out all of the cases that don't belong in the criminal justice system, if you removed all of the stuff that should be placed in other parts of our civil society, if you took people who had mental health issues and you weren't filling prisons with people who have mental health issues and clogging court dockets with people who had mental health issues, and you were really right-sizing the justice system, and you were only bringing those issues before the court that needed to be brought before the court, then you could take plea bargaining completely out of the system and it would not crush in on itself. But if you continue to over-arrest and over-prosecute and mass incarcerate and use the criminal justice system really as the sort of dumping ground for all societal problems, then sure, you need some mechanism to deal with all of that stuff expeditiously, and you raise efficiency over justice. So when a prosecutor says the system would cave in on itself, but for plea bargaining, what they're really saying is we want to continue to over-prosecute, overcharge, mass incarcerate, and then rationalize it with plea bargaining, rather than doing the right thing, which is right-sizing the criminal justice system, taking all of the stuff that should not be in the criminal justice system, all those issues that are better placed other places, and putting them where people will be better served and we'll all be safer. Then you don't have the issue of the plea bargain. So it's just a specious argument, and anytime you hear it, you should let them know that it's a specious argument. And I'll leave it at specious.
I do try, but you're much better at it than me, Rick. Madhurima, can I just ask a question? If just a kind of brief response. In practical terms, are people that are being asked to plead guilty or to waive their rights to a full trial, in practical terms, are they getting access to the legal advice that they need in order to understand the implications of that?
Well, it's difficult to answer the question, but if you're in prison, so now all the prisons in India are mandated to have prison legal aid clinics, and 95% or more of them actually do have clinics. And so in certain cases, yes, I think if you look at systematically, yes, they do have access to a legal aid lawyer. But again, the question still comes about awareness, about how aware they are about the fact that what is happening to them, the consequences, whether they even know about, that I require a lawyer for doing this. Because in my own experience, especially in the guilty pleas, so what happens is usually it's the prison department who's sending prisoner petitions with guilty pleas, and I don't think so they have lawyers there at all. So it's a guilty plea that goes, and then it's accepted, and then you have a sentence hearing, you're given a sentence. So yeah, I don't think so in practice. Right now, we're not there. However, there are some, I think there will be some initiatives taken by the Legal Services Authority to push for the implementation for the plea bargaining laws. Because in certain cases, I do have my reservations, but in certain cases, even I've been pushing for using plea bargaining, especially like, for instance, foreign national prisoners. We have a huge problem in West Bengal of illegal immigrants, and India prosecutes illegal immigrants as opposed to, deporting them back. And for them, I believe that if they know they are guilty, they don't have documents. And for those cases, I believe it's good to use plea bargaining, because you are reducing a lot of burden on the system, which is there, and also you would be reducing the term of sentence as well for them. So yeah.
Thank you very much. Again, I think it's that those cases sound to me like they raise questions about whether they should be in the criminal justice system at all. But hey ho. Do want some time. I've just seen the 10-minute warning, which is probably down to 8 now. So if just very briefly, Kakha, I think there is a proposal to change the availability of legal aid in plea bargaining cases in Georgia. If it's possible, like in a minute or two, can you just give us a brief overview?
Yeah. The question, UNDP Georgia, UNDP and EU project that I'm working for, we've done a research on the Defense Council on legal aid in plea bargaining. We hired a national consultant and also international consultant. And the problem is that right now, everyone who is involved in a plea bargaining negotiation has the right to legal aid. Well, I wouldn't. Well, I said, as the Bar Association says, this is a problem. I mean, there are two sides of the arguments. The Bar Association is against such kind of system because they believe that not everyone involved in the plea bargaining should have a free legal aid. And that should be limited only to those who don't have financial resources. But right now, the Georgian law says that no matter how rich or how poor you are, if you start plea bargaining with the prosecutor, if the prosecutor starts plea bargaining with you, in this case, you have an automatic right to the lawyer. And of course, there are arguments on one side and the arguments on the other side. The research that we did on the international level, it shows that there is no automatic right to legal aid in plea bargaining. Unless you also satisfy the means test, but in Georgia, because it's a very specific and very sensitive issue, we cannot, so far we did not come to an agreement among the Bar Association and Legal Aid Service and the Prosecutor's Office of what is the right approach. Should we eliminate the legal aid for the rich people who are involved in the plea bargaining? Or should we make the legislative changes? Or should we just come to some practical solution so that the prosecutor does not automatically appoint a free legal aid lawyer to everyone? Instead, the prosecutor initially is asking, do you have a possibility to hire a lawyer? And if defendant says no, then the prosecutor can go ahead and appoint a legal aid lawyer. But right now, the prosecutors usually they appoint legal lawyers sometimes even without asking to the defendant if they have a possibility to pay or not for their own lawyer. So, and this question of debate currently right now, but we are looking for a right path for a best approach to this issue. Thank you.
Okay, so we have, I think, about four minutes. Questions. So there's a question over here. Let me take two questions and then, okay, so two questions. Oh, I've got three. Can you make them really brief questions and I'll ask them to be really brief responses? So first of all, please, behind.
Thank you. Can I offer or ask about just a slightly different approach? Whether the problem is in the concept of plea bargaining in itself, because ideally if there's equal plea bargaining power and no coercion in the system, there is nothing wrong in an adversarial system where the different sides can agree to limit the scope of their disagreement. The problem I would like to suggest is all the other things within the system that make the alternative to a plea bargain almost impossible. The trial is unattractive, an unattractive option when there's when there's preventive detention is prevalent, when there's mandatory minimums or rigid sentencing guidelines that distort the plea bargaining process and actually push people to the plea bargaining, and other procedural safeguards that are eradicated. So those are just taking into account that we cannot probably eradicate plea bargaining. I think the focus should be on how to make the alternative to plea bargaining more attractive.
Thank you very much. And there was another question on this side. Please. We'll gather the questions and then we'll respond to all of them. So if you want to do the second question.
Раз. Андрей Мисис, Украина, адвокат. Вопрос грузинскому коллеге. Скажите, пожалуйста, вы говорили о соглашении с прокурором. А возможно ли по вашему законодательству соглашение с потерпевшим? Это первое. И второе. Что делать, если преступление имеет два объекта? Например, хулиганство, которое выразилось в нанесении телесных повреждений в общественном месте. Благодарю. Есть ли возможность заключения соглашения не с прокурором, а с потерпевшим? Если такая возможность есть по грузинскому законодательству, что делать, если преступление имеет два объекта? например, хулиганство, которое полягало, по-нашему, выразилось в нанесении телесных повреждений в общественном, например, месте. Дякую.
Okay, so there was a third question over here, and then I'll hand back to the panelists.
Hello, I'm Hadil Abdelaziz from Justice Center for Legal Aid, Jordan. And although in our system we do not have official plea bargaining, yet we have, it is quite implemented within the court. And my question would be, is how to ensure, how can you actually challenge plea bargaining or decisions that were already made, even with the prosecutor, that are based on misinformation? Because it is not always about coercing. The problem is not about coercing the defendants. In many cases, it is about misinforming them. And at the same time, yes, I understand it is most problematic when you have minimal sentencing. But even with the, it's more likely to happen with very little sentencing, which would, in fact, also have another impact, specifically having a record and its implications. So what would you recommend, or how do you handle challenging these plea bargainings after they've happened?
Yeah. Thank you very much. So I think we can probably, in relation to the first question / comment, I think we were all nodding, and I think we all agreed with this idea about kind of balance of powers, equality of arms, and you know, if that were a real thing in any adversarial justice system, perhaps this wouldn't be such a problem, but it's just not reality. Is that fair, or do you want to add anything on that, Rick?
Well, I don't want to take up too much time. I'm not sure I fully understood the question. One of the problems with you know, the involvement of the prosecutor in the plea bargain is that you give the prosecutor an outsized dosage of power, and the prosecutor becomes the most powerful player in the courtroom when you engage in plea bargaining. And one of the things that both police and prosecutors do, understanding that 97% of cases are going to be plea bargain, is that they, from the very beginning, they overcharge. So if a case is really a robbery in the third degree, and they know that there's a likelihood that it's going to be plea bargain, they'll charge it as a robbery in the first degree, so they can then plea bargain it down to where the case really ought to be. So I'm not sure if I'm really addressing your question or if I understood it fully, but I think that it's not enough to think that the playing field is level when you get into the arena of plea bargaining. One of the major problems with plea bargaining is that the playing field is not level, and that it really takes a lot of power. As much as it does from the defense, it takes a lot of power from the court, and it really invests a tremendous amount of the power and tilts the balance in favor of the prosecution.
Thank you. Madhurima, do you want to add anything on that? No? Yeah, please. And also, Kakha, if you want to answer the second question, would be great.
About the victim.
Yes.
Yes. And there's one comment from the Georgian side, maybe, because the Georgia Legal Aid Service is here.
მოგესალმებით, ირაკიშონია, იურიდიული დახმარების სამსახური. ჩემი აზრით, კოლეგას უკრაინიდან ქონდა მსგავსი კითხვა და შეიძლება სწორად ვერ გავიგეთ. ანუ საპროცესო შეთანხმების დადების დროს თუ არის შესაძლებელი, რომ მოხდეს შეთანხმება დაზარალებულთან. ქართული საპროცესო კოდექსი არ ითვალისწინებს დაზარალებულთან საპროცესო შეთანხმების შეთანხმებას. და არაა ეს დამოკიდებული პროცესუალურად, რომ დაზარალებულის თანხმობა თუ გაგინდა თუ არა საპროცესო შეთანხმება რო გაგიფორმდება. არა. პროკურორი გადის კონსულტაციას დაზარალებულთან და კოდექსი ავალდებულებს, ქართული საპროცესო კოდექსი პროკურორს, რომ გაიაროს კონსულტაცია დაზარალებულთან. თუმცა დაზარალებულის პოზიციას, რომ ამ კონკრეტულ საქმეზე აქვს მნიშვნელობა, ეს არ რეგულირდება და არ აქვს ნამდვილად მნიშვნელობა. რაც შეეხებოდა მეორეს, რომ ხულიგნობის შემთხვევაში შეიძლება ორი დაზარალებული ყავდეს, ანუ რას გულისხმობდა, რომ შეიძლება ერთი ეთანხმება, რომ გაიარა კონსულტაცია, რომ შენ გაგიფორმდეს საპროცესო შეთანხმება, მაგრამ მეორე არ ეთანხმება. თუმცა ამას აქვს მნიშვნელობა არ აქვს, იმიტომ რომ დაზარალებულთან საპროცესო შეთანხმების პირობების გაცნობა და ამაზე საუბარი არის სულთა ფორმალური ხასიათის. ხელშეკრულება საპროცესო შეთანხმებაზე ფორდება პროკურორთან. და დაზარალებულს აქ არანაირი ასე ვთქვათ როლი არ აქვს, გარდა იმისა, რომ პროცესი ავალდებულებს უბრალოდ კონსულტირებას.
Okay. Irakli, guys, let me just one very briefly. I think that Irakli has answered that the victim is outside the criminal. In Georgian criminal procedure, victim is no longer a party. The victim is not a party to the criminal procedure and has very limited rights. In case of plea bargaining, the victim is only consulted, but cannot object or cannot block the plea bargaining. But however, just one very quick point which I made, and I'm going to ask Jago about that. Because in Georgia we are facing this question, whether the right to legal aid should be automatic in case of plea bargaining or not. Did you discuss that question while studying, making the research that you talked about? And is there any approach that you can recommend? Because this is something we are discussing right now. Whether the right to legal aid should be automatic for a defendant in a plea bargaining without the means test, without the means test. That's what you may.
I'm going to get shot by the organisers if I let this session go on much longer. I'd love to chat to you about this question that you raised in Jordan. Basically, it's really difficult. No, it's really difficult to reopen, partly because the defendant has also benefited quite frequently. And so the question is, what situation are you putting the defendant in if you're asking them to kind of reopen the deal that's been struck? We've done some cases at fair trials that have been trying to get at that, including in the US. But it'd be really great to chat about that. In response to your question, if I may, I think you have a real problem if you end up with any system which means that a person is not legally represented at the point of waiving their right to a trial. Because really that's what the ECHR is looking at. It's a waiver of a right, and in order for it to be a valid waiver, you need to be properly informed. So any system which means there might be a delay in the appointment of a lawyer means that the plea is likely to fail. And I think probably you may feel that the current system is inefficient, but actually if you've got to always have somebody there at the time of the plea, you might find that it's probably the most efficient system you're going to get. So yeah, avoid any system which means there's going to be some kind of means test which delays the presence of a lawyer at that crucial point in the case. I'm going to wrap up at this point. There's questions, but we can't because there's a lot more. Betsy, handing over to you. Thank you. Can you join me in thanking the panel? Thank you.